From the main list, item number 1.
Yes.
So there was a missed case, my lord, for condoning the delay of 83 days.
Yes.
Upon notice being issued, my lord, the respondents have filed an affidavit in opposition,
Yes.
which I have received today, my lord. They primarily say the ground we had urged, my lord, for condoning the delay is that 600 odd
That's all
persons,
right.
my lord.
Affidavits are complete.
My lord,
Are you ready
it
with
is complete.
proceed with the appeal?
My lord, if some other date is fixed, my lord, it would be convenient, my lord, because I would like to appear physically, my lord, before your lordship.
In view of the good ground shown and notwithstanding the robust objection thereto by the respondents, the delay of how many days?
53 days, my lord.
Delay of 83 days in preferring the appeal is condoned. Full stop. Since the appellant seeks an accommodation, commanded the matter appear. Let the matter appear 3 weeks hence. Give a date.
Deeply obliged.
One matter only. One matter.
Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list? Item number 1.
End of.
From the
Wait, please wait.
from the main list, item number 1.
The matter. Yes, Mr. Kinter. Yes. Very well, since an accommodation is sought by counsel for the appellant on account of bereavement, let the matter stand over for a fortnight. Paragraph, the rejoinder, if not filed, should be filed within a week from date. Yes.
Much obliged.
This is at land.
My lord.
Yes.
Your Lordship.
Okay.
Item number 2.
My lord, this relates to the Umiam Lake, my lord.
Yes.
Where we are supposed to prepare a draft guidelines, my lord, for
Yes.
protection and conservation of water bodies. My lord, in this regard, the draft has been prepared and sent for comments from all the concerned departments, my lord.
Very well.
And
It is, an affidavit has been filed by
Secretary.
the secretary to the state government in the Forest and Environment Department. Full stop. Paragraph, such affidavit indicates that the subcommittee of experts has drafted a set of norms and guidelines for future construction around water bodies in the state. Full stop. It also appears that that draft guidelines for protection and conservation of water bodies have also been submitted. Full stop. The state submits that the draft guidelines have been circulated for comments from various departments and district council.
Yes, ma'am, including district.
And the district councils, full stop. Paragraph, accordingly, let the matter stand over for 4 weeks.
My lord, let it be 8 weeks, my lord. We'll try to finish up within this time.
But don't do anything around the water bodies. till
Yes,
then.
that will not be done.
At the request of the state, let the matter stand over for 8 weeks. For a firm stand pertaining to the guidelines to be indicated. Full stop. Paragraph. In the meantime, the state will make every endeavor to preserve all the water bodies in the state and not allow, and neither the state nor the local authorities will allow any construction to come up within 50 meters of the high watermark of the relevant water body without the express previous leave of this court.
Yes.
Your Lordship, we'd like a copy of the report state can give us also.
They've said they forwarded it to you, sir.
To all the concerns.
Very well. It will be open to the parties herein to obtain copies of the draft guidelines from the state so that they can better assist the court. Yes.
Much obliged.
Item number 3.
Please, Your Lordships. Lordship, this is a appeal against the acquittal.
Appeal against?
Acquittal, my lord, under 302 and 207, my lord. I pay for the first respondent, my lord,
Yes.
With due apology, Lordship, I was not in a position to prepare, my Lord, because of a bereavement in my family. I'm
That
praying
was
for
on 3rd of May, sir.
yes, my Lord, because of the rituals and all. I'm praying for a short accommodation
Since
to
further time is sought on behalf of the first respondent, let the matter appear a fortnight hence.
Much obliged, Lordship.
You got away because of the heavy matter today, otherwise today you wouldn't have got away.
On the next day, I'll positively do it, my Lord. Much obliged.
Item number 4. Item number 1.
Please.
May I, my Lord? Accept. Lord,
Just to assist you in what you need to address and what you need not.
Lordship.
Just for that purpose.
Yes.
Two fundamental arguments have made. First is that for all intents and purpose, the order of reference required all of them to be heard by one same panel. Therefore, since the panel which passed the impugned awards is not inclined to take up the other reference and the other reference have advanced, this should be annulled and sent to that. You don't have to answer that.
Right.
The next is bias, given up, you don't have to answer that. Then there are the 7 heads. The first head is interest, you will fail over there. You will fail on interest, which is a substantial kind of relief.
Yeah.
Then the other heads are delay in supply of explosives, delay and short supply of cement and steel, tunnel collapse, rock strata deviation, access roads, delay in construction, drawings being made over in time, and delay in boulders being made available.
Yes.
Now, as far as explosives is concerned, and cement and steel are concerned, they say that there are some clauses which appear to be expressed, but we will deal with that. But the main point over here is that the objections that they had indicated may not have been adequately dealt with by the tribunal, one, and to the extent that reasons for coming to the conclusion have not been given, which becomes, suspect under 31(3). And also a ground of patent illegality as a consequence. These are the two you have to. As for tunnel support, rock strata, access roads, construction drawings and boulders, sufficient reasons are given. You don't have to deal with those heads. Then there is this fundamental point that you have to deal with, quantification. We found at least two places, they say that till this point, 21.40% was completed.
Lordship.
And therefore, so you'll have to justify that.
I'll do that.
And you don't have to justify it to the hilt.
I appreciate.
All you have to do is, that's a possible view.
Correct. I'm grateful.
Only to that extent.
Right.
On the others,
yes,
you don't have to. On the interest, you'll fail.
My Lord, I'll endeavour, my Lord, your Lordships, I'm sure, my Lord, have an open mind to this.
Yes.
And I'll, my Lord, endeavour, my Lord, to show that, of course, my Lord, subject, of course, to your Lordships, my Lord, prerogative. How I, my Lord, propose to, my Lord, deal with this, how I've structured my argument for your Lordship's consideration is. Now, my Lord, this is regarding claims 1 and 2, because this is where, my Lord, all the objections regarding cement, steel, and so on and so forth have been taken. Now, what I propose to do is, my Lord, give your Lordships an overview of the award. And, my Lord, what was the controversy between the parties? What were my claims? How the tribunal dealt with it? And how did it quantify my claim, my Lord? So your Lordships, my Lord, get a sense of, my Lord, how the tribunal has proceeded in this matter. Along with that, my Lord, I also want to emphasize the fact that, my Lord, that there is a primary obligation, which the tribunal has also found, which was to provide the principal access road of a certain standard all the way to the project site and an alternate road.
Were these, they were engineer arbitrators?
Yes.
They were engineer.
Engineer.
No one was a lawyer or a
None
judge.
of them was.
And their nominee was a Vasant Kunj man, and the two others were non-Delhiites.
My Lord, I don't know, that I'm not entirely sure, but it perhaps, my Lord, I'm sure your Lordships have seen the record.
Yes.
So that could well be the case, my Lord. So, my Lord, so the submission is, my Lord, which I'm going to try and make good, is that the primary obligation was for them to provide the principal access road of a certain standard and an alternate route. Now, the tribunal has found that this has been this is a fundamental breach of the contract, because this was one of the main obligations, and this obligation had a cascading effect as far as supply of materials is concerned, which includes cement, steel, explosives, and so on and so forth. Now, my Lord, so I'm going to... No, that's all right. Whoever was the arbitrator, doesn't matter. My Lord, is just, it's not important. So, my Lord, that is the second part with which, my Lord, I'm going to my Lord, address my Lords on. And, my Lord, then I'll come to the individual heads. My Lord, your Lordships, I'm grateful to my Lord. My Lord, I've narrowed down what I have to address my Lords on, so I'll just confine myself to that. Now, my Lord, as far as the contract is concerned, your Lordship may just make a note of 2-3 basic facts which are not in dispute, which is that, my Lord, the letter of intent was issued in my favor on
21st of September.
28th of September, 2001. I'm so deeply obliged. And the contract provided that it had to be completed within a period of 24 months, which expires on 27th September 2003. So 100% of the work of the value of 67 odd crores.
28,901, 24 months.
Is 27/9/2003. That's, my Lord, the end date of the entire 67 and odd crore contract. 100% of the contract ought to have been completed.
And the suspension is April
9th June 2004
to January 2011.
2011. But your Lordships are only concerned up to 2005, because the others is, my Lord, part of the second reference. Now, my Lord, it is also not in dispute that by 27 September 2003, only 21.4% of the work was done.
By 27 September
2003, which is the end date,
only
21.4% of thereabouts. Not, I don't have the exact figure. 21.4%.
No, that's the exact figure.
21.4% of the work.
Now you say no dispute.
Yes.
Why do you say no dispute?
No dispute, because, my Lord, the value of the work was 67 crores, and they themselves have said that about 14.42 crores of work had been done, which translates to 21.4%. That's also the finding of the tribunal, not challenged before your lordship.
Value of the work was 67 crore.
And odd, my lord, I can give your lordships the figure.
Work done was
14.42 crores.
42 crore. And this work done, the figure was supplied by them?
Yes, my lord. That is not, they themselves not admit it in their own contentions, that's the amount of work.
Show it to us wherever. But
I'll do that. So 21.4% of work was done. So, my lord, there is a shortfall of roughly about 78.6% or 79%, which is, my lord, the shortfall. Now, my lord, please see, now may I invite your lordships to see, my lord, the award itself. Because, my lord, admittedly, my lord, there was slow progress of work. It's quite clear from both sides, my lord, that the progress did not, my lord, match the timelines which were provided for in the contract. Now, what are the causes for that delay? What are the hindrances that have occurred? And who is responsible for the hindrances? Now, my lord, kindly turn to, my lord, the volume that my learned senior colleague had, my lord, placed before your lordships, the award volume, lot 1. And if I may be, my lord, if I may kindly invite your lordship's attention to page 90. Lord, it's titled Additional Documents, Volume 1.
Yeah.
Yes. Now, my lord, just before I may not invite your lordships to see some of these, I'm just going to give your lordships an overview. There were
At page 90, there's a sketch map.
Yes, sketch map. I'm grateful. Now, my lord, I had pleaded that there were 8 hindrances which were responsible for the delay, and all of these 8 hindrances were attributable to them. That was my case before the tribunal.
What were these hindrances?
Lord, the road,
Those 7?
those 7 plus 1 power.
Power.
Yes, that
Power has been rejected.
Rejected against me. But those 7, my lord, have been, the tribunal has found in my favor. So 8 reasons, 8 hindrances I had given, and the tribunal found in my favor. They gave 8 reasons, and the tribunal rejected them all.
That's the counterclaim.
No, they also, yeah, that's the counterclaim, but also, my lord, justification for defense to my claim. Saying that, my lord, when I had claimed that I'm entitled to compensation for the delay, that's, my lord, that was their case. So, my lord, page 90 onwards, the tribunal begins to analyze. So, the first, my lord, your lordships will see up to H, which is, my lord, your lordship will find is at page 103, ends at 104, are, my lord, the
Access roads.
No, it starts with access roads, my lord, at page 90.
90.
And, my lord, your lordship will turn over the page to page 95, and your lordship will see B, delay due to non-issue of construction drawings.
First is access road, then drawings, then delivery and explosives.
Yes.
Short is cement and steel.
Yes. Then electric power, which is rejected.
Yes. Then is
collapse of tunnels.
Collapse.
Yes. Then
is
boulders.
Boulders.
And rock strata.
Finally, you have rock strata.
Yes. And then, my lord, your lordships will see from I are, my lord, the hindrances which they say, which are attributable to me, and the tribunal begins to consider those.
And how many heads?
8 heads. They also had 8 heads, but all of them were rejected. Which, my lord, starts at page 104 and, my lord, ends at page 110.
And there has been no challenge really.
There is no challenge to that.
110.
It's actually 111, my lord, the first para, it ends there, and then the final conclusion is drawn by the tribunal.
So this is a very important paragraph at the top of 111.
111. So what the tribunal was doing at that point in time, my lord, was analyzing the hindrances. What was the cause of the delay? Who was responsible for the same? Now, my lord, the hindrances result in, the consequence of the hindrances that, my lord, there is idling of equipment, manpower, and, my lord, machinery. So, my lord, my claim, your lordships will find, I'm sorry to take your lordships back to page 42, which is what my claim was. if your lordship would be so kind as to have, my lord, Romans 7. These are the claims.
Yes.
It says the claimant summarizes its arguments in support of claim 1 by stating that the respondent prevented the claimant from fulfilling its obligation in the contract for reasons only beyond the control of claimant and for reasons which cannot be attributable to the claimant. Claimant states that the work could not be completed within the stipulated period and the originally quoted prices became unworkable and the cost structure of the claimant became totally disturbed. This constituted a breach of reciprocal obligations under the contract on the part of the respondent, because of which the claimant had suffered losses and damages under the following heads. So these are the heads of claim: rental charges on idle underutilized plant and so, payment made to manpower deployed through subcontractors, and so on and so forth. So there are 11 heads your lordships will see. The bullet points at number 11.
Yes.
Now, my lord, the tribunal thereafter, my lord, examines each head of claim. And that your lordships will find is at page 129. I'll come to this in a little while, my lord, when I'm dealing with the quantification point. But I'm just giving at the moment, my lord, an overview of how the award has proceeded.
Yes.
And your lordships will see, my lord, I'm just reading from the table. Each of those heads are considered. And your lordships will also find, say, for example, on the first page 129, 3, serial number 3, my lord has seen. My claim was 1 crore 6 lakhs, they've given me 0. So out of 11, my lord, heads of claim, 5 heads of claim, my lord, they rejected. 6 heads of claim, they gave me not the amount which I had claimed, but a reduced amount under each head.
Yes.
So, my lord, this is what the tribunal does. It accepts 6, rejects 5, and 6 also on the reduced amount. Now, the basis of this, my lord, is contained in Annexure 1, which your lordships will find is referred to at the top of, my lord, 15.2 Roman 1.
Yes.
Sorry.
Accepted 6.
Accepted 6 heads of claim, but gave me reduced amount, not the amount which I had claimed.
Yes.
But rejected 5. Now, my lord, if your lordship would be so kind as to come back to page 129, 15.2 Roman 1, entitlement of the claimant to claim has been deliberated as above, and accordingly the award amounts have been computed. Detailed computations are in Annexure 1. Now, my lord, if your lordship would be so kind as to have Annexure 1, which your lordships will find is at page 151. Now, just pausing here for a minute, my lord, I just want to point out one thing to my lord. Your lordships, my lord, have seen that, my lord, the end date was 27 September 2003. By that date, only 21% of the work had been done. So, what the tribunal does, and this is basis my claim, because it's not possible to attribute a particular hindrance and correlate that to a particular machinery, correlate that to a particular amount of manpower. What they have done is that they have said that since by 27 September 2003, 100% progress ought to have been achieved, but you ended up achieving only 21.4. That means that for 79%, we are going to give you the idling charges. That is how the tribunal has proceeded. That is how I have made my claim. Because there is no way. And even if, my lord, a respectful submission is, even if, my lord, for example, if your lordship were to set aside the award and we were to go back to any tribunal, it's simply not possible for any tribunal to, my lord, bifurcate and say that for this hindrance, this machinery, this manpower, and therefore correlate all of them and then give a separate.
It is possible. You don't assess damages with mathematical precision.
Correct. I'm so deeply.
There is an element of guesstimation that
I'm so deeply
thing, but there are certain overarching principles.
Yes.
The first is it has to have reasonable nexus between cause and effect.
Correct.
You know,
Absolutely.
and those textbook kind of graphs that we have in assessing damages.
Yes.
And the other one is it must be relatable to the purpose.
Yes. Correct. So deeply black.
You know, sometimes for want of a horseshoe nail, the battle is lost.
True, your lordships are right.
You know, because the horse was lame and the horse fell and the battle was lost because of a want of a horseshoe nail. So insignificant things can sometimes lead to disastrous consequences.
Yes.
But of course, that is for them to reason, rationalize and indicate.
Correct.
It can never be on ipse dixit.
Right. I appreciate that. Now, my lord, your lordship will just see, for example, illustratively, if your lordship will just have page 151, which is, my lord, the first page. I'm going to give a couple of examples, my lord, and the rest of it is just exactly the same. If your lordship would be so kind as to have serial number 2, A2.
Just a second.
I'm sorry.
15.2 plus page 151.
Now, just pausing here for a minute, my lord, I just may indicate to my lord that, my lord, the figures which are given here, we had filed 14 volumes of documents along with our statement of claim, photocopies, and they came and inspected the original. So, my lord, there is no dispute as far as, my lord, that is concerned, that the documents were placed and they inspected, obviously, because a large volume we don't.
The ground has been taken.
Yes, right. Now, my lord, if your lordship will have serial number 2, for example, because the first one was transferred, diesel portable air compressor. Has my lord got that?
Yes.
Now, my lord, your lordship will just see the third column, the date of induction for the project is 27th November 2001.
Yes.
Now, my lord, the cost of this machinery is 7,65,000. 66,000, I'm sorry. 66,000. The recommended life is 10 years, which roughly translates to in hours 12,000 number of hours. Now, my lord, each of them is the same way. Lordship may kindly now turn over the page. Now, my lord, your lordship will see serial number 2 again. So the recommended life in hours per year is 1200 because this 10 years was 12,000, per year is 1200. Now what I have been given is the depreciation charge. Now this is, my lord, the formula your lordships will see on top, 0.9, because what is regarded under the CWC guidelines, you could regard 10% as the scrap value. So 0.9 multiplied by the cost divided by the number of hours gives you this figure of depreciation. 68,990. Has my lord got that?
Yes. How do you arrive at that?
My lord, 0.9 is an arithmetical figure. It is multiplied by C, which is the cost, and divided by the number of hours.
Yes.
So the figure that comes is 68,990.
Now, just come to this entry, number 2 in the first page.
Yes, ma'am.
It shows recommended life in hours is 12,000
For 10 years.
for 10 years
Yes, so in 1 year it will be 1200. So depreciation is being calculated per year.
per year.
So now when we
The
are,
straight line method, and
Yes.
you've given some.
right. So now, my lord, if I may invite your
What
lordship.
is the hourly depreciation?
Yes. Now, my lord, what happens? So there is one component of depreciation which is given to me because during this period the machinery would have depreciated. They then give me interest because the machine is lying idle. Had I, my lord, said use it somewhere else, it would have, my lord, earned me some money. So basis that, my lord, they've used this formula and, my lord, given me of 75,890.
And what is that formula?
That formula is 18%, your lordship, 0.18, your lordships have seen on top, on the 5th interest it says. 0.18 multiplied by C multiplied by bracketed 1 plus N bracket 2N. This is all as per CWC guidelines.
Where is that? Where is the assertion that this is as per CWC guidelines?
But in this body, right now it doesn't
Should
say.
be, but
Yes.
elsewhere in the award, do they say?
Yes, there is a reference to CWC guidelines and that's what they have done. They have followed the CWC guidelines, especially for claims 3, 4 and 5, there is a specific reference to that. I'll come to, my lord, that. But this is the formula which has been used. I can place the guidelines here. If your lordship would be so kind, my learned friend says 161. Yes, I'm sorry, I'm obliged to my learned friend. If your lordship will just have, my lord, 161 At the foot of that page, there are two notes. Look, Your Lordship will kindly have note number 2. Has my Lord got that? It says Central Water Commission Guidelines for Preparation of Project Estimates for River Valley Projects, March 97, so-and-so edition. So this is how, my Lord, they have computed it. So, my Lord, what happens is, and now, my Lord, so for each machinery, my Lord, this is how they have computed it. Now, my Lord, finally, please come to page 158. Now, my Lord, your Lordship will see, it says anticipated progress as per program, 67 and crores 52 lakhs, my Lord had noted that earlier. The actual progress due to slowdown and stoppage is 14.42 crores. Shortfall in progress is 79%. Total rental charges as per program, which is, my Lord, the calculation, is 6 crores 4 lakhs 24,000. Non-utilization of machinery, 79% of that, and that comes to 4 crores 77 lakhs, which is what the tribunal has granted to me. So, my Lord, that is how the tribunal...
This is granted you in respect of lot 1 only.
No, in each of the lots. I'm right now only addressing your Lordships on lot 1. But, I'm sorry, lot 1, my Lord, there is only claim 1, right? Claim 1 and 2, which is not common to the others. So, my Lord, as far as this is the similar, my Lord, annexures are there.
So this is 4 crores 77 is on account of what? Claim 1.
Claim 1 for lot 1.
Claim 1 for lot 1.
Yes.
Now you had given us a color coded.
My Lord, if your Lordship will have page 157. Sorry. My Lord, please have page 157.
157. Yes.
At the foot of that page on the right side, my Lord.
Yes.
It says claim 1 lot 1. Has my Lord got that?
Yes.
Just below the
lot
table.
1. Yes.
For 28th so and so. And that is how, my Lord, the tribunal has proceeded. There is a whole, my Lord, chart which is given. Even for manpower, CWC guidelines, my Lord, provide. In fact, the contract provides that out of the total cost or the bid that you make, 25% will be attributed to manpower. So what the tribunal does is it calculates what is there for the total manpower, reduces it by to 79%, and then gives 25% of that, and that's how, my Lord, they have computed as far as manpower is also concerned. So in each instance, based on the contractual stipulation or CWC guidelines, based on the actual, my Lord, machinery which was lying idle, the tribunal has gone ahead and computed it. And that is why, my Lord, what if your Lordship will just come back to, my Lord, page 129, sorry. If your Lordship will come back to page 129, what had happened in this case, my Lord, was that when I made my claim on the basis, say for example for the machinery, that the machinery would be used for a full period of 24 hours every day, 3 shifts a day, and with a multiplying factor of 1.7. The tribunal did not accept it, and please see, my Lord, Roman 2 of 15.2, it says in computation the multiplier factor is taken as 1.0, not 1.7, and the AT has considered the following: vehicles used for staff has not been considered, machines transferred to lot 2 and 3 has not been considered, for 2 shifts instead of 3, available hours have been considered as 12.5, old equipment bought in the year 81-80 are not considered, as the work has been continuing, only interest on delayed realization of profit that the claimant would have earned but for the delays has been considered. And that is how my claim, because reduces from, in the first instance for rental, from 14 crore 6 lakhs to 4 crore and 77, which your Lordship saw at page 158. And so on and so forth. That is how, my Lord, that is why my learned friend, my Lord, initially didn't question the quantification until, my Lord, it fell from your Lordships, and that's why I'm satisfying your Lordships as to how the tribunal proceeded in this matter. They didn't accept everything that I was asking for. They used the CWC guidelines and their own, my Lord, assessment of how many hours the machinery would be used and should have been used, and given me depreciation and the cost of, my Lord, hiring it out, and so on and so forth for manpower. So, my Lord, this is how the quantification took place. Now, my Lord, sorry.
So, the table which is there at 159, 129, 130,
Lordship, please.
what does it reflect? This is in respect of which claim?
Claim number 1. Your Lordship will see page 131. At the end it says, when the table ends, it says total for claim number 1, claimed amount is 40 crores 54 lakhs and the amount awarded is 1482.
And then what is there at page 158?
158 is the first entry. Your Lordship will see the entry number 1 in this 4 crores 77. So the chart goes on. I am just giving one example to my Lord. I mean, I can take your Lordships through each one of them. And it accepts some, rejects some, and moves on.
Where is this number 2? Manpower deployed?
Yes. The manpower, your Lordships will find. I'll just show it. Where is it?
163.
I'm grateful. I'm grateful to my senior colleague. 163. May I read, It says payment made to manpower deployed through subcontractors so-and-so suppliers rendered idle, underutilized during the stipulated period as a consequence to various hindrances beyond control of contractor. Claimed amount is 11 crores 81. Then payment to workers under category of HO contract services without indirect charges, with indirect charges. Indirect being, for example, you provide food to them, housing to them, all of those other, not just direct salaries. And so they are all added up. And the amount, which is arrived at.
How can with indirect charges be less than without indirect charges?
It's more, Your Lordships will see 12 crores 7 lakhs.
First one, 38, 22, 538. On the right is 34, 42, 84.
Yes, Your Lordships are right, I'll have to check that. I didn't see that, notice that entry. Perhaps because of the star, the footnote says claimant has claimed indirect charges only on 50% of basic salary of HO staff. That perhaps is the reason why, it is less, only as far as that is concerned. Yeah.
Claimed indirect charges only on 50% of basic salary of HO. But it can't be less than that.
No, because he's reducing it because my claim is only that much. Because he cannot give me more than what I have claimed.
No, that's not the thing.
Sorry.
You see, number 1.
Yes.
You're saying without indirect charges.
Yes.
And he's saying the asterisk over there is claimant has claimed indirect charges only on 50%.
Has claimed, yes.
Has claimed only on 50%.
Lordship, please.
Now over here, it's the claimed amount only.
Yes.
It's not the awarded amount.
Yes.
At page 163,
yes,
we're looking at the claimed amount.
Yes.
Anyway, but there is an anomaly. How can it be less than what is in the first column? Can never be. Even if you claim 50%,
yes,
it will be a bit more.
Your Lordships are right. I'll get instructions. I'm not in a position to assist your Lordships on that. I'll just get instructions.
This payment required to be made labor at the rate of 25%.
This is provided in the contract because they said 25% component is for labor. And so they only take 25% of it.
In terms of contract.
Yes. And that's how the amount comes to 8 crore 55, which your Lordship saw it. And so on and so forth. It goes on.
And thus,
out of a claim of 40 odd crores, your Lordship saw at page 131.
So ultimately the total amount awarded is 1480 in respect of lot 1, or is that claim 1?
That is claim 1. Claim 1 of lot 1.
Claim 1 of lot 1. Yes.
So, my lord, that is how it is quantified. Now, my lord, this also takes me
What
since...
is the total quantum of the award that you've got under the first, under all the things?
My lord, that is...
Principal amount?
I'll just indicate, my lord. Your lordships had posed this query yesterday, my lord. We should have done the... I'll just get instructions on it. I don't want to detain my lords for that. Now, my lord, the second part, and this is a very important part, my lord, especially with reference to the specific objections which have been raised by NIPCO, is, my lord, that there is a fundamental breach which is committed by them and which is noticed by the tribunal at starting page 90. I had initially invited my lords to see that, because this is most important as far as the contract is concerned. There were, my lord, if I may just broadly indicate to my lord, there were, my lord, there were 3 roads leading to the project site. There was one principal access road from Bilkhatuli to Saifam, to Sci-Fi, and then to the project.
Sci-Fi? Then to Sci-Fi.
Saifam, yes. Lordship's right.
And Sci-Fi,
I'm sorry, my lord, I stand corrected.
13 kilometers from the project site.
Yes, yes. I'm so deeply obliged. Your lordships much more aware than what I am. So sorry. The second one, my lord, was to be provided by them by April 2001, which would be only
BRO.
70. No, BRO is the first one. Is still to be improved.
The second one is NH 34.
My lord, I don't know.
54.
My lord, there was a road to be constructed by them. They have not yet constructed. Even now, I'm told they have not constructed it.
The second one is the alternative route they allowed you for the mobilization purposes through NH 34.
Yes, that's the third road. In my example, that's 250 kilometers for the initial mobilization.
But that says at no extra cost to the...
Yes, for the initial mobilization. Yes. And thereafter, my lord, so there were 2 principal obligations. One was, my lord, that there was this principal access route to Sci-Fi, Saifam, and, my lord, the project site, which was about 116 kilometers. And there was also an obligation to provide, my lord, an alternate route by April 2001, which was only about 70 kilometers, 46 kilometers shorter in distance. Now the tribunal finds, after a detailed, my lord, analysis of both the construction program as well as, my lord, what had transpired about the repeated letters that we had written, and this is where, my lord, page 90 to 94 of the award become very important, saying that you never provided the road of the standard that was required to be provided. They had to provide all weather access roads capable of carrying 20 tons of load.
10-degree gradient.
10-degree gradient.
And at 25 to 30 kilometers per hour.
I am so deeply obliged, my lord. I am so deeply obliged. Your lordships will not fully remember this. So, my lord, that was part of the construction program. You had asked for the construction program to be provided. It is part of the contract. You didn't provide. And the alternate road, my lord, they never provided at all, which is claim number 6. My learned friend has not really, my lord, argued on that point as much. But this principal obligation, the failure to, my lord, provide the principal access road of this kind, is, my lord, the genesis of why there was, my lord, delay in supply of explosives, cement, steel, everything else. It had a cascading effect, is what, my lord, the tribunal has also held. So, my lord,
Where is that?
I show it to you.
That is what we don't
that is what I want to show to my lord. There are at least 4.
We'll of course give some latitude.
Yes.
They are not judges or lawyers. They are engineers.
Yes.
There are certain things they take for granted.
Right.
Like when we write judgments, when lawyers read it and laymen read it.
Correct.
It's 2 different kind of understanding.
Right.
So when engineers write it, when other engineers read it, and laypersons like us, from engineering point of view, read it, it is different.
It is totally.
We have to give them that latitude.
I'm so deeply obliged.
As long as we find what is fundamental, the application of the mind to the matters in issue, to arrive at the conclusion. That's the only journey that we are interested in.
I'm so deeply obliged, my lord. And let me, my lord, show to you straight away. Lord, kindly have page 90 from where, my lord, the discussion starts. I'm not troubling your lordships with, my lord, the initial narration which has been made.
Up to roughly 101, I think we've read it.
My lord, but there are some paragraphs which I want to just point out, if your lordship would just kindly, my lord, indulge me. If your lordship now turns to page, my lord, 92. In fact, 93.
Yes.
Lord, please have the last 4 lines at page 93. It says 80 states that the respondent was obliged to provide access roads as required under the construction program, and non-fulfillment of this fundamental and essential requirement, which are in the nature of contractual stipulation, will result in fundamental breach of the contract. Now, I'm going to kindly turn over the page 94, the third bullet point. The tribunal finds and decides that due to bad conditions of the principal access road prevailing over the entire contract period up to 27/9/2003 and continuing beyond till as late as June 2005, the claimant could complete only 21.4% of the value of the contract. The respondent provisionally extended the contract period up to 30/4/2005 without levying any LD under the contract, thereby deemed to have accepted the reasons put forth by the claimant for the delay in completion of the works. No document was produced by either party to show the final extension till 30/9/2005 and was granted. However, the claimant could not, through the execution of works in the original contract period, fully recover the depreciation charges of the plant and machinery planned and brought at the site of work as per the construction program forming part of the contract, utilize the manpower deployed during the contract period of 24 months and recover the overhead expenses due to less value of work executed, and is therefore entitled to unrecovered part of depreciation and manpower. The contractor has also claimed loss of profit due to unexecuted portion of the works. The respondent has averred that the unexecuted portion of the work was completed by the contractor during the extended period and as such is not entitled to loss of profit. However, the tribunal decides that the claimant is entitled to interest on the loss of profit delayed during the contract period over the claim. Now, my lord, your lordship, may kindly turn to page 97. Now, my lord, this is D. This is on the question of cement and, my lord, steel. Please have the third bullet point.
The 3 issues.
The 3 issues: delay due to non-availability of principal access road being constructed and maintained by the respondent, delay in issue of construction drawings, and non-supply short supply of explosives has a cascading effect on the progress of construction, that is, planned use of cement being not possible. Then, my lord, your lordship will turn to page 106. This is, of course, my lord, dealing with one of the hindrances, my lord, which they had claimed. My lord, your lordship, what? 106? Just on top of that page first. Third line, the bad road conditions existing right from the contract was awarded, and delay in providing the principal access road and other access roads as per the contract conditions, of which the construction program is an integral part, has a major contribution in the delaying of the project beyond the original time limit of 24 months. Then, not kindly have K in the last 3 lines of the third bullet point, where it says,
This situation.
the situation has a cascading effect on further activities in mobilization of machinery and manpower. The claimant has also pleaded that it was compelled to revise the construction program on 4 occasions. And, my lord, the previous sentence of that also, my lord, is exactly the same as what your lordship saw. Then your lordship will have page 110. Please have P, the third bullet point, last 3 lines. The AT also notes that the claimant's reference to the letter dated 7/6, wherein the access roads issue has been raised and said to be affecting the transport of construction materials. The AT finds that once again it is the bad road conditions causing problems of mobilization transportation not only for the claimant but also for the respondent, who had the contractual obligation to supply construction materials like cement and steel to the works as per the construction program. The administrative requirements to get the permission from the Forest Department of neighboring state of Assam delayed the extraction and transportation of boulder, stone, so and so. In view of these interdependent conditions, the delay is primarily on account of reasons attributable to the respondent. So, my lord, these are all interdependent. Say, for example, my lord, I was just taking instructions. When the tunnel is being constructed, the explosives are needed. So, my lord, to blast. But when you use the explosives to blast, immediately thereafter there must be steel support which is to be provided, otherwise it begins to fall. Followed by, my lord, concreting. So if any one of these is not there, then, my lord, the use of that material it cannot be, my lord, made. So therefore, my lord, all of these obligations are interdependent between one another, and especially given the fact that now principal access road is not being provided, these materials, this machinery, equipment, manpower is all getting, my lord, delayed on this account. And, my lord, one last page where, my lord, again the tribunal, my lord, makes a reference to this. There was, my lord, they dealt with the legal submissions. If your lordship will be so kind as to have page 239, the legal submissions start at page 235. The consideration of the legal submissions starts at page 235. And, my lord, I am inviting your lordships to kindly see page 238, my lord. My lord. May I read? Para 4. It says the tribunal finds that the contract between the claimant and the respondent under the adjudication does not contain facts and conditions similar to so and so. Facts in the present case are briefly as below. And your lordship will kindly turn to page 240. At the top of that page, the tribunal finds that the claimant has not pleaded frustration of the contract but has stated that the respondent has failed to keep up its promise to provide the principal access road and the access road, which is the alternate road, to the standard stipulated in the construction program forming part of the contract, resulting into delay in performance for which the respondent alone is responsible. Needless to say that without approach road in place, machinery materials cannot be brought to the site by the claimant to perform as per the construction program, and for the consequential delays in performance of the contract, the respondent alone is responsible. So, my lord, as I said, what the tribunal has proceeded on the basis of is essentially this, that, my lord, this was a primary obligation that obviously there is no way in which materials can be transported, heavy machinery can be transported, which is, my lord, of 20 metric tons with that speed that your lordships have seen, without, my lord, the road being in place. And that is the primary driver of why, my lord, all of these delays have occurred. That is what, my lord, the conclusion of the Honorable Tribunal is.
Do you have the Contract Act?
Yes, my lord, I do.
55 and 56.
55, my lord, I have seen.
And 56.
Yes.
Our law is different from the English law.
Yes, correct. Your lordships are right.
You either can get out of it for breach.
Yes.
Or you put them on notice.
Yes.
I'll continue.
Yes.
Subject to charging you for it.
Yes.
And then when you proceed, you can claim.
Yes.
Without that, can you claim?
My lord, first and foremost, my lord,
See 56.
Yeah, 56, my lord, is agreement to do an impossible act.
Yes.
Agreement to do an impossible act in itself is void. Contract to do an act afterwards becoming impossible or unlawful. A contract to do an act which after the contract is made becomes impossible, or by reason of some event which the promisor could not prevent unlawful, becomes void when the act becomes impossible or unlawful. And compensation for loss through non-performance of act known to be impossible or unlawful, where one person is promised to do something which he knew or with reasonable diligence might have known and which the promisee did not know to be impossible or unlawful, such promisor must make compensation to such promisee for any loss which the promisee sustains through the non-performance of the promise. Now, my lord, first and foremost, this section, with great respect, my lord, is in my respectful submission not applicable, because it's not either party's case that it was impossible or unlawful. 55, my lord, your lordships are right.
Forget the unlawful part of it.
Yes.
We are on the impossibility.
Yes.
Impossibility of it is because within the time indicated, this was not possible to do.
My lord, with respect, no. This was an obligation cast on them. This is part of their performance to ensure that there is a road of that, my lord, standard. Now, it's one thing to say that that you will not perform the contract, as a result of which the performance becomes impossible. My reciprocal promise, my reciprocal obligation to, my lord, transport and...
Your obligation to discharge
Yes,
your promise
yes,
comes upon this primary condition being fulfilled by them.
reciprocal, your lordship.
In the absence of that,
Yes,
you can hold tight.
right,
You can terminate. You can hold them accountable for breach.
yes,
But you accept their underperformance, breach, and you continue executing your promise without notice to them that they are liable for damages or additional payment for you to you. This in Indian law is difficult to sustain.
No, my lord, I first and foremost, my lord, I may, I'll just examine that point, my lord, with reference to, I don't, that's not the point which they had canvassed, but I'll just examine that and come back. The one other thing, my lord, that I must point out to your lordships is that, my lord, under section 34, the erroneous application of the law is not a ground for interference. So therefore, my lord, that's a statutory, my lord, provision which is provided for.
That's the only answer.
My lord, if that is answer good enough, my lord,
The answer, that's in the first page of the old Russell.
yes, that's right.
That a mistaken law is not
Yes.
a ground for setting aside an award.
So, my lord, I'll come back on the 55, but, my lord, that is one answer, my lord, which I'm advancing for your lordship's consideration. So, my lord, my respectful submission, as I said, overall is this, that the primary obligation, which was the driver of all the other obligations, was for them to provide the road of that standard, which they did not do. And therefore, my lord, the consequential delays. Now, as I said, my lord, it is not possible to apportion and say this, and so, my lord, I'm not troubling your lordships with that. Now, my lord, having said this, I'm going to now move on with the specifics of what my learned friend has argued. Now, before that, yes, sorry.
Which lot is what and what is still not clear to us?
Lord, your lordship will just have that.
Color-coded thing,
Yes.
you have to go through that to explain.
Okay.
Because it's still not clear
Yes.
as to what claim comes in respect of
Okay.
which.
May I not take your lordships through that
Yes,
then?
yes.
Just show that color. Yeah, that's good. Now, my lord, may I read from the first column, first row?
Yes.
Now, my lord, this is compensation for losses, extra expenses due to acts of omission and commission by NIPCO for the contract period commencing from 2001 to 27 September 2003.
Original completion date.
Yes. Then comes, my lord, the second period,
Extension.
extension period, 1/10/2003 to 31/5/2004. So that's the only difference between claim 1 and claim 2 in lot 1. Right? Now, my lord, coming to Roman 3, in the same, my lord, column, compensation for losses. Now we are now entering into a different period, which is, my lord, when the work has been suspended. So compensation for losses, extra expenses incurred due to suspension of works for the period commencing from 9/6/4 to 31/3/2005. Then, my lord, Roman 4 is 1/4/2005 to 36/2005. Roman 5 is 1/7/2005 to 30th September 2005. So, my lord, just the periods are different. The claims are the same, the periods are different. And finally, my lord, Roman 6 is claim for reimbursement of extra cost of transportation of materials through longer routes, so and so, due to non-availability of the shorter road, Baga Bazaar to Sci-Fi, which is the, my lord, 70-kilometer road, which was never constructed. And the seventh, my lord, of course, was rejected, so I am not troubling your lordships with that. I have not challenged it, the matter ends there. Now, my lord, if your lordship will see lot 2, your lordships will find, again, this is for the, my lord, period which is during suspension, 9/6/2004 to 31/3/2005. Then the second one is for
Financial years.
Yes. No, it's not financial years, my lord. It is not the quarter. It is
quarters. Yes,
it's quarters.
financial years.
Because it's not exactly quarters either. The first one is not a quarter.
First one is not.
Second and third are.
Second and third are.
And then, my lord, again, the fourth claim is, my lord, for the shorter road. Fifth is, my lord, again rejected. And similarly for lot 3, your lordships have seen. And then, my lord, of course, for the 2 roads, again for the same periods.
Now, in respect of, so you had one reference for lot 1, one reference for lot 2, another for 3, then 17 kilometer
That's
road,
why there are 5 matters before.
13 kilometer road. Now tell us, what is principal and interest?
I'll tell you, lordship.
Under 1, 2, 3,
What I'll do is I'll give another chart where I'll not mark the total amount which is being granted. Principal, how much?
It's been recorded in the interim judgment itself by the Unit Commercial Court. He's starting of the interim judgment. He has set out the table.
Okay.
These are the interest components, total award, total here. So this is the table of outline.
All right. So, my lord, I'm grateful to my learned friend. If your lordship will just have the appeal paper book, where, my lord, the section 34 court has, my lord, indicated the amounts. What the amount of principal per claim, and, my lord, and the interest component, and how much was, my lord, finally given. That is
claimed, awarded.
Awarded, then principal, that is principal awarded, then interest awarded. What is the total number? Page 780.
Principal awarded is whatever it is in respect. Interest is, I think, uniform. It's 18% pendentility and 12% post-award.
Lordship, please. Lordship, please. Lordships are right. But the computation of how much that amount comes to is not indicated here. So, my lord, page, your lordship may just make a note, 780 to 782 of the appeal paper book. The figures are given for each of the lots and the 2 road contracts.
Actually, for the road lots, the quantification is not. Okay.
Lord, I'm grateful to my learned senior colleague. For road, my lord, that quantification is not there.
For the interest.
For the interest, I'll just, my lord, I'll make sure that.
This is numerical. It's only percentages. For lot 1, lot 2, lot 3, it actually give a numerical value to it. Because it's all noted here in the table. It just, the road contract, it just gives the percentages. That's
Yes. My lord, the amount of
One
the
thing,
what's the amount?
on a different note, you people are still as primitive as us. We thought that, you'd come with artificial intelligence passing around your head with gadgets and no paper.
My lord,
You're as primitive as this village.
my lord, artificial intelligence comes once when one has primitive intelligence. One is grappling with that itself. So, artificial intelligence is a far cry. But, my lord, typically in the High Court and in the Supreme Court, my lord, typically we do it through the laptops only. It's just that, my lord, this has come from below, and there has been a whole host of, that's why it's troubling also to not carry all these bags. And the lordships are right. Now, of course, the times are changing. So,
though I am still primitive, we use paper. So.
Yes.
now, my lord, may I just move on to the specifics? But before that, I want to make, my lord, one preliminary submission, which, my lord, is on rather first principles, I would say. First, my lord, my learned friend, my lord, accepted that, my lord, the 2015 amendments will apply. Now, your lordships have seen 34(2)A says patent illegality. Going to the root of the matter, trivial mistakes are not something that your lordships would, my lord, look at. There is no reappreciation of evidence, no merits, my lord, examination, erroneous application of the law. Your lordships will not look at. Now, if your lordships would kindly have section 28 subclause 3 of the Arbitration Act for a minute. Please, my lord, have that.
Section?
28 subclause 3.
That is what was used in saw pipes.
Yes. But that is what is the difference now. That is what
That is the difference now.
Yes.
Because
So-
the author of saw pipes,
Yes. Justice Shah.
Yes, Justice Shah, I had once asked him that, in the 1996 regime, how did you open it up so much? Because it became almost wider.
Yeah.
The answer was the rampant corruption going on in the arbitration industry.
It's true or not?
Because particularly if you see all those cases going up, Department of Irrigation, State of Odisha, there were 10 rupee contracts on which 10 crore awards were being passed. In fact, we had one matter in Calcutta where for a tube well, where the contract was worth 1,50,000, an award had been passed close to 70 lakh.
My God.
And after 7 years, one retired judge dying and another retired judge delivering just before her death for just sinking a tube well. Yes.
Lord, please have 28.3. But before your lordships read the main provision, Lord, would your lordships just see what was the pre-amended position? Lord, I hope, my Lord, that is also extracted in your lordships, my Lord, Act. Pre-amended 28.3. Has my Lord got it? Must be in the foot of the page, my Lord.
No, it's not there.
My Lord, may I just pass on the changes?
No, I have a different book.
My Lord, may I just pass on the changes? I have it. I have typed it out.
I'm looking at, sorry.
Oh.
I'm looking at the contract act. Yes.
Lord, 28.3. Would your lordship see the pre-amended first? May I read, my Lord? My Lord, it says, Roman 3, in all cases, the arbitral tribunal shall decide. And the important words are, in accordance with the terms of the contract, and shall take into account the usages of the trade applicable to the transaction. So you had to decide in accordance with the terms of the contract and take into account. Now, my Lord, why the amendment was brought about was because of, my Lord, the ONGC saw pipes case. And this is...
I have an entire judgment on this amendment. The effect of the amendment. I have an entire judgment.
Okay, I'm so sorry, my Lord, then we should have...
Yes.
Now, my Lord, if your Lordship would be so kind as to have the Law Commission report, may I just place that for your Lordship's consideration as to why, my Lord, this change had come about. Just keep going.
That won't help in interpretation.
No, my respect...
It's completely diluted. It's taking into account is being mindful of.
Yes.
Whereas in terms is acting strict to sensu.
I'm so deeply aware. That is the point.
That is my judgment.
Yes. All right. I'm deeply obliged. Then I would rely on that judgment. Because, my Lord, what the Law Commission...
Because if it shows that you were oblivious to the contract,
yes,
then yes, 28 would be attracted.
Yes.
But if you saw it,
yes,
and interpreted,
yes,
as long as you're mindful of the contract and take that into account, that passes.
That is enough. So, my Lord, my respectful submission is that therefore, if your Lordship will just have the Law Commission report, just 2 paragraphs of that I have extracted.
This is AP Shah.
Yes, my Lord, this is the 246 Law Commission report. My Lord, your Lordship will just see the top of the page, which is, my Lord, the bottom it says page 22.
Yes.
Just up top of the page, the amendment to section 28.3 has similarly been proposed solely in order to remove the basis of the decision in ONGC and in order that any contravention of a term of the contract by the tribunal should not, ipso jure, result in rendering the award becoming capable of being set aside. So, my Lord, my respectful submission is merely because there may be a so-called prohibitory clause. That by itself is not sufficient if in case the tribunal has not acted in accordance with it.
If the tribunal had noticed
yes,
what is 55 probably here,
yes,
and had said, interpreted it,
yes,
and had given a possible view,
yes,
we would have accepted it. But if the tribunal does not recognize the existence of 55,
yes, but I believe that
it would fall within the amended provision, does not take into account.
Yes. My Lord, there are two answers. I see what is falling from your Lordships. 2 answers to this. I believe, my Lord, section 55 was, my Lord, raised and has been...
Mr. Amadi's come here only for the interest. He is happy if interest goes. The rest is just to, push the judges to give him interest.
I'll address on the interest also. I'll just straight away come to that, but I just want to point out, Milord, two answers to this. Milord, 55 was considered, I'm told, Milord, in the award, but in a different context, and I'll not place that for your Lordship's consideration. The second aspect is, Milord, that I'm on the prohibitory, so-called prohibitory clauses on which my learned friend places reliance to say that you cannot make a claim for these delays and so on and so forth. So the only point I'm making is that it becomes a matter of construction. It is not that your Lordships will find that if there is a prohibition, ipso facto, my Lord, your Lordships will say the award is vitiated. That by itself, your Lordships will not draw that conclusion, which was the earlier position, that if in case it is contrary to the terms of the contract, you are out. Then that means that the award must fail, award must be set aside. But that's not necessary.
That is the underlying principle even in the interest cases now. If you see Jayaprakash.
Yes, I'll come to that, my Lord.
It says that if it is contrary, it goes.
Yes.
So therefore, that principle will still remain.
My Lord, I would agree, but
if it is capable of any other interpretation, where the latitude must be given to the arbitrator and to the other party, so to say, contractor,
right?
Then, all right.
Yes.
But if there is no room for the view which has been indicated, then it has to be shut out.
Right. Now, my Lord, two
principle.
Yes, right, absolutely right. May I only just point out this, that, my Lord, Jayaprakash does not consider the amendment to 28(3). It is not an authority for the proposition that even post-amendment, because this was not occasioned, nobody cited it for the Honorable Court's consideration, that post-amendment, merely because it may be directly contrary, is not enough, unless
that, with respect, I don't think we'll be able to agree with you.
All right.
Post-amendment of 28,
yes,
directly contradictory would also not pass muster. But, say it says, no claim on account of interest will be entertained, period.
Yes.
No, nothing else.
Yes.
Any claim on account of interest has to be set aside.
Right.
But it says, if the claim is made on a Sunday and it is considered on a Monday, then they should not be taken into account.
Right.
And if they fit through the gap, if the claim passes through the gap, so to say, in the wording, and it is possible, then of course we will.
I'm so deeply obliged. That is
what is prohibited is prohibited.
Yes.
28 does not affect that.
My Lord, I accept that. I'm so deeply obliged. I bow down to that. So, my Lord, my endeavor will be, when I come to the merits on the interest, is that on the construction of the clause, this interest is, my Lord, not barred.
There you're hit by Jayaprakash.
That is not, my Lord, applicable.
It's one para-materia.
It is not. I'll tell you, Lordship. So I'll come to that. Your Lordship may just bear with me for a minute. Yeah. Okay, I'll come to that in a minute. Now, my Lord, as far as the interest is concerned, I have two submissions to make. The first, my Lord, as I had, my Lord, indicated to my Lord yesterday, which was, my Lord, that the prohibition was not pleaded. My learned friend showed the written submissions, but I want to just make the point for your Lordship's consideration. The SOD doesn't make a reference to the prohibition. In the course of oral arguments, also, my Lord, this is not canvas for the Honorable Court, Honorable Tribunal's consideration. And, my Lord, so
I don't know that.
Because there is no discussion. I'll tell you, Lordship, why your Lordship would know that. Because there is no discussion in the award 1.
That there is no discussion does not mean that it was not raised.
2, in the section 34, they don't say that they raised it and it was not considered. It's not their case. That's why, my Lord, it is critical for your Lordships to consider. Now, my learned friend, my Lord, has placed the written submissions before your Lordships. 135 pages of written submissions. And, my Lord, your Lordships recalls, my Lord, on the first day itself, your Lordship, when my learned friend had asked your Lordships if we gave written submissions, your Lordships have said, no, there is a tendency in all of us, my Lord, especially on this side, that, my Lord, we argue something and then become wiser after the event and, my Lord, then put in more points. Your Lordships cannot be expected to, my Lord, look at every single line and say this point has been taken. And this is, my Lord, been settled by a constitution bench, saying that you cannot say that you had taken, in fact, in a pleading, that you had taken a ground, but the court did not deal with it. And that is a ground for, if you did not canvass it in the course of,
where do we have evidence that they did not canvass it?
Because it's, as I said, in the SOD it's not there. It's not there in the...
It may not be there in the SOD, but not everything is reflected in a judgment. Not everything is reflected.
But if it is not,
In fact,
yes,
one of the most difficult things to do is to hear a matter and dictate straight away.
Yes.
Why? Because then the lawyers are present.
Yes.
They'll stand up and tell you, I referred to this, you have not dealt with that.
right.
But it's easier to go to your chambers and come back tomorrow without referring to half the things that have been argued.
Right.
Now, over here, merely because
Yes.
it's not been recorded does not mean that it's not been.
My lord,
It was pointed out in the written submission, since they've accepted the filing of written submission. Whatever is contained in the written submission, it was their obligation to go through. And in any event, they have said, we have not found anything.
yes.
When there is a prohibition, that prohibition should have
My
been.
lord, would your lordship, two things, my lord. I see, my lord, I'm sorry, but I have to canvass this point. Your lordship will just come to, my lord, page 131 of, my lord, the award. Because what was the case?
This is claim 1, this is claim 2.
Yeah. Yeah. Sorry, that's good. Just take out my file.
Expensive. 143 will claim 3 or 4 or 5.
Lord, your lordship can be so kind as to have page 131.
Yes, sir.
Interest, not Roman 5. Please have the second bullet point. Although there is no specific denial, the AT notes that the respondent has stated that the claimant is not entitled to any amount of compensation or other relief as claimed for. Claim is required to be rejected summary. Your lordship then turns to, my lord, page 136. First bullet, my lord.
Your trump card is your Achilles heel.
I'm sorry?
Your trump card is your Achilles heel. Because they still deal with it.
Yes, because I made a claim.
But they still deal with it.
Because
The claimant is not, because there is a denial, they notice a denial.
yes.
So there is assertion, there is denial. Then it calls for adjudication. And
My lord, I would respectfully submit. In fact, I'm going to cite my lord's own judgment given 1 month ago, where, my lord, your lordships have said that unless there is a specific...
not on interest.
It was not on interest, but what your lordship said was that if there is no reference to the specific clause that you are relying on, then you cannot thereafter turn around and say before the...
There is reference to 55 in the written submission.
No, 55, but 55 is on the larger compensation. It's not on the question of interest. I'm on the question of interest. I'm on the question of interest, that the interest, as far as interest is concerned, they did not give any denial. And Lord, may I just only complete this, page 136.
Just a second. Yes.
Lord, again, first bullet point, although this is regarding claim 2 in lot 1, although there is no specific denial by the respondent, it has stated that the claimant is not entitled to any amount of compensation or other relief as claimed for. Claim is required to be rejected summarily. And lastly, my lord, page 143, Roman 10, this is with respect to, my lord, claims 3, 4 and 5.
Show 146. Claimant is claimed interest. The respondent is receiving the SOD to learn the amount of so no claimant is entitled. So even in the SOD they haven't given the interest. So he has considered this also. And then he is granted of the interest. This is claim 6.
Lord, page 143, Lord, Roman 10.
31(7)(b) is post award.
Post award. That, my lord, of course, not subject to contract.
Now, of course, that is also amended. It's
2% over
above the-
Yes, that's right. My Lord, kindly have Roman 10
Yes.
at page 143. As regards the interest after declaration of award till the date of payment, AT is considered as follows. 1. AT finds no specific denial from the respondent for the claimant's claim for interest. And finally, my Lord, one last page, which is page 146. Please have, my Lord, Roman 5. That page. 146. The claimant has claimed, my Lord, Roman 5 at page 146, claimed interest by stating further interest at 18% may be granted by the tribunal from the date of the award to the date of payment. Respondent has stated in SOD that in the premises and facts and situations, the claimant not entitled to any claim. Other than a general bald denial, my Lord, there is nothing. They did not argue it. And that is why, my Lord, they did not take the point in 34 that they argued it and it is not being recorded correctly. And there, my Lord, where I must cite that, and I'll tell your Lordships why they didn't do it. If your Lordship will just have the appeal paper book for a minute. Please have, my Lord, the appeal paper book, page 246. Lord, kindly have page 246. Lord, your Lordship finds these are the terms of reference. Has my Lord got that? Now, my Lord, actually the first page of that is 248. This has got, my Lord, interchanged. Just to show, my Lord, it says 1.0, the following claims are referred to arbitration for adjudication. And Lordship comes back to 247. Number 3, interest/financing charges on claims shall be paid as per the decision of the arbitration panel. And this is exactly, my Lord, a similar situation had arisen in Susaka's case, where, my Lord, ordinarily they should have said that it's only on the counterclaim that the interest can be given by the tribunal because there is a prohibitory clause. The terms of reference say interest to be decided shall be paid as per the decision of the tribunal.
Yes, even on the claim interest will lie post-award interest.
Yes.
On the claim interest lies post-award.
But whether they give it or not is not important, my Lord. If they don't give it, I would still be entitled. By law, I would be entitled.
By law, you would be entitled.
So therefore...
But they can reduce it.
No, of course they can reduce it.
Like they have in your case 12%.
Yes, they can do it. Your Lordships are right. But I'm saying that there is no qualification here to say that this is only restricted to the post-award period or that it is not. And this is exactly, my Lord, the situation which arose in Susaka's judgment of the Honorable Supreme Court. Let me just place that for your Lordship's consideration.
Mr. Dholakia, you are experienced enough to know.
Yes, my Lord.
That all that we do is a charade. At the end of the day, whether it pricks the judge's conscience in allowing something, that is what is important. The rest is a charade.
Yes.
We give excuses running into 100 pages to justify why we have decided that way. This is something which...
My Lord, I am grateful to my Lord, my Lord. I see what is falling from your Lordships, but my Lord, the standard that your Lordships have laid down is the prick is not enough. It must shock.
Yes.
And so, my Lord, whether this shocks the conscience is something...
That is for which there is no other remedy.
Yes.
Here, the prohibition is a remedy.
Yes.
When prohibition is a remedy, a mere prick is good enough. When there is no other remedy, then it has to be shocking.
My Lord, with respect, my Lord, I can only canvass this. I'll leave it at that. I'm not going to, my Lord, belabor the point. But my respectful submission is, point once not taken, you're barred. The tribunal had no, my Lord, possibility to consider it. I can understand you canvass it and the tribunal disregards it and then gives the award.
You invite written submission.
Yes.
That written submission is filed.
Yes.
And the particular clause that they rely on now is the one which is cited, referred to very clearly and categorically.
Yes.
these are not circumstances we can say that are not.
My Lord, may I just, I'm so sorry, my Lord,
because we are aware of what the original principle. The original principle is that Maharashtra Chief Minister case, that what transpires before that forum.
Right.
And this is a spin-off from that.
Yes.
If you haven't canvassed.
Yes.
Plus there is statutory support in one of the sections.
Yes.
In the new act.
Yes.
That are capable of waiving, capable of giving it up.
Right.
But not when you have pointed it out categorically. Anyway, let's see.
Lord, just two judgments and then I'll leave the matter at that. So, Lordship will just have Susaka's judgment, my Lord. इनको दे दो. May I read, my Lord? Paragraph 14, if your Lordship would be so kind as to have para 14.
Yes, sir.
It says, placing reliance on clause 13.3 of GCC, learned counsel urged that since clause 13.3 provides that no interest will be payable upon earnest money or the security deposit or amounts payable to the contractor under the contract except government securities, respondent 1 claimant was not entitled to claim interest on any of the heads. In other words, the submission was that the tribunal misconducted awarding interest to respondent 1 on various claims when clause 13.3 did not allow them to claim any interest on the sums payable under the contract except on government securities. It was therefore her submission that the award to this extent was not legally sustainable. 17. In reply, the learned counsel supported the impugned judgment and contended that the aforementioned point urged by the appellant was neither raised nor heard before the tribunal, nor the High Court, that is a single judge, and also the division bench, and hence it cannot be permitted to be raised under 136. 18. Having heard the learned counsel for the parties and on perusal of the record of the case, we are inclined to accept the argument of the learned counsel of respondent 1, as in our view it has force and hence deserves acceptance. It is not in dispute that the appellant did not raise the plea based on clause 13.3 of the GCC at any stage of the proceedings, either in the reply filed before the tribunal and or in the submissions, except raising it for the first time before the court in appeal. On the other hand, we find that in section 11.5 proceedings, the appellant did not raise this objection in their reply and instead gave their express consent to refer the said issue of award of interest payable on various claims to the tribunal, considering the said claim to be arbitrable under the contract. In our opinion, the appellant could have registered.
I'm sure you're not citing paragraph 20 as law of the land.
No, that's
Come on, where are we? In 11, you have to anticipate and take that objection. Absurd.
I see what is falling from your Lordship, but anyway, that is the judgment. That is one Lord argument. The other is
that is not the ratio decidendi over here. That's not the ratio decidendi over here. That's an additional part. It was reading outside, therefore. That's not the dictum which is made.
Right. So,
because if I concur,
yes,
to a reference,
yes,
does it mean I can't take an objection? I concur. I don't file an affidavit. I agree. In your petition, you did claim on interest, this, that, and the other, everything.
Yes.
Does that mean I don't have a right to object?
But in fact, your Lordships are absolutely right under section 16.
We'll take off on this paragraph. That cannot be the law.
But in fact, your Lordships are right. Section 16 says that even if I have participated in the appointment, I can still challenge the jurisdiction. I see that, I'm just not citing it because that's what the Honorable Supreme Court says. One last judgment and then I'm done on the preliminary part, which is Daman Singh's case. Lord, it's a judgment of the Constitution bench. Your Lordship would be so kind as to have that. Just one paragraph of that. But kindly have paragraph 13.
Yes. 85(2). Paragraph 13.
Lordship, please.
Plus, you've got to realize in our country, we are very lax both on pleadings and on this kind of because the quality that we have, both that side and this side, is so abysmal that if we were to go strict on pleadings, most of the litigants would have been killed. Half the time we are correcting your mistakes or our mistakes. And that's the colossal waste of time because of the general standard and lack of domain knowledge.
True, your lordships are right. I don't think we demand enough of ourselves or expect enough of ourselves. It's more a chalta hai attitude,
Absolutely. And you see at the end of a lot of frivolous things, no costs. No one is accountable for perjury. So if the plaint says that the plaintiff is an Indian citizen, or the writ petition says Indian citizen, the first affidavit in opposition is denied he is Indian.
All denials are welcome.
All denials.
Lord, may I please paragraph 13?
Yes, sir, please.
The final submission of Sri Ramamurthy was that several other questions were raised in the writ petition before the High Court, but they were not considered. We attach no significance to this submission. It is not unusual for parties and counsel to raise innumerable grounds in the petitions and memoranda of appeal, but later confine themselves in the course of arguments to a few only of those grounds, obviously because the rest of the grounds are considered even by them to be untenable. No party or counsel is thereafter entitled to make a grievance that the grounds not argued were not considered. If indeed any ground which was argued was not considered, it should then be open to the party aggrieved to draw the attention of the court, make the order, to do it by filing a proper application for review or clarification. The time of the superior courts is not to be wasted in inquiring into the question whether a certain ground to which no reference is found in the judgment of the subordinate court was argued before that court or not. So, my lord, that's why I say that this is in fact regarding pleadings, not even written submission.
This is something which is not possible in an arbitration. This principle you cannot apply to arbitration. Once they are done, functus officio.
True, your lordships are right. But obviously,
in court you can go. So in the 151, even if you don't go under Order 47 or whatever, you can go under 151. Right.
So, my lord, where is the remedy? The remedy is in saying in section 34 that my point was not recorded by the tribunal. Surely, I understand they are functus officio, they cannot go back to the tribunal. But surely, my lord, then they would take the point.
But when you say in your 34 that the interest has been wrongly awarded,
yes,
just because you don't add the extra line that it is not even looked into, I don't think it's
Lord, I'll leave it at that.
What you can do,
yes, my lord,
aside this is, you can take us to the clause and say the clause does not imply a bar.
I'm going to presently.
That you're at liberty to do.
So, my lord, I'm presently inviting your lordships there and move on. My lord. Would your lordships not kindly come to, my lord, clause 55, which, my lord, my learned friend had not placed for your lordship's consideration in, my lord, appendix C. Although my learned friend had highlighted the whole thing, I'm going to read the whole clause for your lordship's consideration.
Give us an escape.
I'm sorry?
Give us an escape.
Yes. So, my lord, this...
Because we are always, as a court, it's our duty not to interfere, to let it go. Right. So, you give us an escape.
I'll endeavor to do that. I'll endeavor to do that. Lord, may I... Sorry.
This is why we don't give the papers to them. In the course of Where is appendix C?
No, otherwise I can show from the.
No, just a second. Yes. No, I know. I kept it in a particular place. He took it out from there. Page?
No, not first page.
Yes.
Interest. It says time for payment and interest. No claims for interest or damages will be entertained by the corporation with respect to any money or balance which may be lying with the corporation owing to any dispute, difference or misunderstanding between the engineer in charge on the one hand and the contractor on the other, or with respect to any delay on the part of the engineer in charge in making periodical or final payments or in any other respect whatsoever. Now, my lord, this is the clause which can be found in the agreement. Now, my lord, there's one judgment of Harish Chandra, as it was considered in Jai Prakash, but I want, my lord, your lordships to kindly see that first. Would your lordships kindly have the judgment in State of Uttar Pradesh versus Harish Chandra? I'll just, my lord, place that for your lordship's consideration. Lord, your lordship may keep the clause 55 side by side, so that, my lord, your lordship will be in a position to compare the clause, my lord, in the present case with the clause which was dealt with by the Honorable Court in Harish Chandra's case. My lord, kindly
Please
turn.
remember Harish Chandra was 40 Act.
Yes, I appreciate that. I'll come to that, my lord. Please have, because right now we are on the construction of the clause.
Just a second.
Sorry.
1999 1. Yes.
Now, my lord, kindly turn to internal page 67.
Yes.
And now, my lord, I'm going to read the clause. No claim for delayed payment due to dispute, etc. Now, my lord, please compare it with the clause at hand. No claim for interest.
Or in any other respect whatsoever.
Yes, and it says which may be lying with the government. Now, please see what the Honorable Court says. A mere look at the clause shows that the claim for interest by way of damages was not to be entertained against the government with respect to only a specified type of amount, namely any monies or balances which may be lying with the government owing to any dispute, difference between the engineer in charge and the contractor, or misunderstanding between the engineer in charge and the contractor in making periodical or final payments, or in any other respect whatsoever. The words "or in any other respect whatsoever" also refer to the dispute pertaining to the monies or balances which may be lying with the government pursuant to agreement, meaning thereby security deposit or retention money or any other amount which might have been with the government and refund of which might have been withheld by the government. The claim for damages or claim for payment for the work done and which was not paid for would not obviously cover any money which may be said to be lying with the government. Consequently, on the express language of this clause, there is no prohibition which could be culled out against the respondent contractor that he could not raise the claim for interest by way of damages before the arbitrator on the relevant items for adjudication. So, my lord, exactly the same. Now, my lord, this judgment, my lord, came to be considered in a subsequent judgment of Saeed Ahmed. Now, please see the vital difference in the language of the clause which was there in Saeed Ahmed versus, my lord, what was there is Harish Chandra. Harish Chandra being pari materia with our clause.
Saeed Ahmed is in the engineer's displace line.
Yes.
Saeed Ahmed is in the engineer's
Yes,
displace
but of course, my lord, even in Jai Prakash.
There's a Mandana also. All of them are in the same line of cases.
Right. But not Saeed, in Jai Prakash,
Yes.
the Honorable Court says that Saeed Ahmed holds the field. That's what it says. Would your lordships kindly have the judgment in Saeed Ahmed? Lord, may I invite your lordships to kindly see paragraph 7. May I read, my lord, the clause? It says, no claim for interest or damages will be entertained by the government with respect to any money or balance which may be lying with the government. And then the next words are important. It says, or any, it should be, or may become due. These words are absent in the Harish Chandra's case, on my case. Owing to any dispute, difference, or misunderstanding between the engineer in charge on the one hand and the contractor on the other hand, or with respect to any delay on the part of the engineer in charge in making periodical or final payment, or any other respect whatsoever. So there is a phrase in the middle, or any, or may become due, which is not there in Harish Chandra, it is not there in my case. Now, my lord, Harish Chandra is cited, but before that, may I just place for your lordship's consideration, page, paragraph 10 for a minute, and then, my lord, I'll come to the consideration of Harish Chandra in this case. May I read, my lord, para 10?
Yes.
Ultimately, this court made it clear that the arbitrator had the jurisdiction and authority to award interest for the three periods, namely pre-reference period, pendent elite and future period from the date of the award, if there was no express bar in the contract regarding award of interest. So even under the 1940 Act, an express bar for award of interest was a ground, my lord, to not grant the interest. Now, my lord, please turn to paragraph 18.
No, but there is a distinction is made in
Yes.
engineer's space,
Yes.
and which distinction is missed over here,
Yes,
is that there may be an express bar on a party
yes,
which does not operate on the arbitrator
yes,
under 40.
correct.
Now, over here, all that they see is the express bar in the provision without making that distinction between bar prohibiting arbitrator and bar confined to parties.
Right. Right, I follow what is following from it. Now, my lord, kindly turn to paragraph 18. And 19. In Harish Chandra, a different version of clause 1.09 was considered. Having regard to the restrictive wording of that clause, this court held that it did not bar award of interest on a claim for damages or a claim for payment for work done and which was not paid. The court held that the said clause barred award of interest only on amounts which may be lying with the government by way of security deposit, retention money, or any other amount, refund of which was withheld by the government. But in the present case, clause so-and-so is significantly different. It specifically provides that no interest shall be payable in respect of any money that may become due, owing to any dispute, difference, or misunderstanding between the engineer in charge and contractor, or with respect to any delay or part of the engineer in charge in making periodical or final payment. The bar under clause G so-and-so, in this case being absolute, the decision in Harish Chandra will not assist the appellant in any manner. So the phrase, my lord, or may become due, was the critical distinguishing factor which, my lord, persuaded the court to hold otherwise. Otherwise, my lord, it is not that the Harish Chandra case or the construction placed by Harish Chandra is wrong. Now, my lord, please then turn to the judgment that my learned friend cited, which was, my lord, the Jay Prakash case. Now, here also, my lord, it's rather interesting. Yes. First, my lord, may I cite below? Sorry.
Oh, Jaiprakash, you give us this bad Xerox copy. So have you got Jaiprakash?
Yeah, I got it, my lord. I'll give it to my lord.
Yes.
No, 2012, no, 2019 also.
Yes, this is Jaiprakash.
My lord, this is 2012. The judgment my learned friend cited was 2019. There are two Jay Prakash judgments. Yes. This is the first one which is followed by the other. Yeah, I'll just leave. Sorry. Now what your lordships will notice immediately is, my lord, this is a case also under the 1940 Act.
Yes.
Now, my lord, kindly turn to paragraph 14.
Yes.
And my lord, there are two clauses extracted here, clause 1.2.14 and 1.2.15. 1.2.14, no claim for delayed payment due to dispute, etc. The contractor agrees that no claim for interest or damages will be entertained or payable by the government in respect of any money or balances which may be lying with the government owing to any disputes, differences or misunderstandings between the parties, or in respect of any delay or omission on the part of the engineer in charge in making immediate or final payments or in any other respect whatsoever. And then this is not exactly as ours. Then 1.2.15, interest on money due to the contractor, no omission on the part of the engineer in charge to pay the amount due upon measurement or otherwise shall vitiate or make void the contract, nor shall the contractor be entitled to interest upon any guarantee or payments in arrears or upon any balance which may on the final settlement of his accounts be due to him. Now please kindly turn to paragraph 19. Clauses so and so already extracted and analyzed imposed a clear bar on either entertainment or payment of interest in any situation of non-payment or delayed payment of either the amounts due for work done or lying in security deposit. On the basis of the discussions that have preceded, we therefore take the view that the grant of pendent light interest is not justified. So, my lord, they look at both the clauses, 1.2.14 and 15, and say that as a whole, read as a whole, there is a complete bar. That's the construction. But they don't say that 1.2.14 by itself is a sufficient bar. They take both the clauses together and say that there is a complete bar. Now, this is exactly what happens in 2019, which is now under the 1996 Act. And they follow this. Having said that the 1940 Act is different from 96 Act, they unfortunately they somehow follow this only in saying that this construction which has been placed is the construction that we must follow. And that is what I'll give your lordships a better copy. And if your lordship will have paragraph 3, where your lordships will find clauses 50 and 51 extracted. My learned friend read them a lot. I am not troubling your lordships, but they are couched in exactly the same language as 1.2.14 and 1.2.15. Paragraph 3, sorry. And para 4 says they are not construing both the clauses together. And, my lord, where they follow the judgment is, my lord, your lordships will find, is at paragraph 18. Another reason given by the High Court is equally convincing. Clause 50 and 51 of the GCC are pari materia with 1.2.14 and 1.2.15. Those clauses have been interpreted by holding that no interest is payable on claim for delayed payment due to contractor. Same construction adopted in respect of these clauses, which in fact is a case between the same parties, is without any blemish. And, my lord, again para 17 just above that, the court, my lord, is again construing 50 and 51 together. There is no distinction which is made by the Honorable Court to say, my lord, that one clause is itself sufficient to, my lord, bar interest.
Except 8.
I'm sorry?
Paragraph 8.
Yes, ma'am. Dilating, may I read, ma'am? Dilating on the first submission, an attempt by Mr. Suri was to show that the clauses in the contract in question, when interpreted correctly, would clearly bring about these clauses did not prohibit arbitrators from granting interest. The learned counsel emphasized the words or any other respect whatsoever occurring in clause 51 of GCC and argued that these are to be read ad usum generis and should take their color from the earlier part of the clause. He submitted that when these clauses words are read in a aforesaid manner, it is only in those cases where some amount or balance is lying with the respondent because of any dispute, difference or misunderstanding between the parties is not payable. Such a situation would not arise in those cases where claim is raised on the other counts and awarded by the arbitrators. He also submitted that clause 51 was similar to clause so-and-so of Harish Chandra case, and the court interpreted the said clause to mean that the arbitrator was not precluded from awarding the interest. In this hue, his alternate submission was that two similar or almost identical clauses are interpreted in a different manner in Harish Chandra, and therefore conflict arises which needs to be resolved. In my respectful submission, there is no conflict because there are two clauses in Jay Prakash, and here there was only one clause. And then, of course, the Mr. Banerjee's submissions are recorded. And then again, he again relies on 50 and 51 together. And then, my lord, your lordships will find para 14, where my lord Ambika is dealt with. And my lord, may I invite your lordships to see para 16, where my lord Reliance Cellulose is quoted. My lord, I am reading from Placitum G, just above Placitum G. Thus, when one contrasts a clause such as the clause in the second Ambika construction case with the clause in Tehri Hydro Development Corporation Limited, it becomes clear that unless a contractor agrees that no claim for interest will either be entertained or payable by the other party owing to dispute, difference or misunderstanding between the parties or in respect of delay on the part of the engineer or in any other respect whatsoever, leading the court to find an express bar against payment of interest, a clause which merely states that no interest will be payable upon amounts payable to the contractor under the contract would not be sufficient to bar an arbitrator from awarding pendent allied interest under the 40 Act. As has been held in the first Ambika construction case, the grant of pendent allied interest depends upon the phraseology used in the agreement, clauses conferring power relating to arbitration, the nature of the claim and the dispute referred to the arbitrator, and on what items the power to award interest has been taken away and for what period. We hasten to add that the position has been explained in some of the judgments under 31(7) of the Act, 96 Act is wholly different, in as much as 31(7) of the 96 Act sanctifies agreements between the parties and states that the moment the agreement says otherwise, no interest becomes payable right from the date of the cause of action until the award is delivered. And then thereafter the court proceeds to deal with the Harish Chandra's case. Please have paragraph 20. Please have Placitum D. It is pertinent to mention that the aforesaid judgment also discusses and analyzes Harish Chandra. In the first place, the judgment in Harish Chandra is a 1940 Act. More pertinently, this judgment is explained and distinguished in Saeed Ahmed in the following paragraphs, which, my lord, I had read to my lord. I am not troubling your lordships, but there, the language was different because it had said, may become due, which is absent in our case. But I don't know, this is a distinction that it then seems to make. And thereafter, if your lordship would be pleased to, my lord, have paragraph 21. It is also pertinent to note that the judgment in Saeed Ahmed distinguishing the restrictive wording in Harish Chandra has been consistently followed by this court. In number of cases thereafter, in this scenario, when we find the Harish Chandra case, which is of the vintage of 1940 Act and is distinguished in Saeed Ahmed, coupled with the fact that the ratio of Saeed Ahmed has been consistently followed, there is no reason to deviate from the construction to clauses 50 and 51 of the GCC given by the tribunal in the first instance as well as High Court. Above all, these clauses are pari materia with clauses so and so and so and so of the first EHDC case, which was a judgment between the same parties. So, my lord, my respectful submission is that as far as the clause with which lordships are concerned is, this is not, my lord, a case which deals with that at all. Because it deals with, partly it does, I can't say at all, partly it does, but that is not sufficient for a complete bar. And the complete bar comes from both 50 and 51, and which is absent, there is no pari materia clause in our case.
50.
Yes. Would your lordship have paragraph 3? No omission. In heading is interest on money due to the contractor.
Due to contractor.
On the part of
the engineer in charge to pay the amount due upon measurement otherwise shall vitiate or make by the team very well, nor shall the contractor be entitled to interest upon any guarantee
or payment in arrears,
arrears,
nor upon balance which may be
on the final settlement of his account be due to him. So therefore, this is confined to payments in terms of the contract,
Yes.
not extraordinary payments.
Yes.
And this is only confined to that. The other one is, or in any other respect whatsoever.
Which what your lordship saw was interpreted in Harish Chandra's case to mean that money lying with the government. I read that passage out to my lord, my lord. And my lord, in my respect, full submission here again, my lord, there.
That Harishchandra,
It's ultimately, as your lordship not quite correctly put it, my lord, it is a question of construction. Construction has been placed on such a exactly the same clause. Just that clause, no more.
if they had referred to Harishchandra, Jayaprakash, and then arrived at the same conclusion after referring to 55, we could have said that. But here they have not taken into account 55. They've completely not taken into account 55, which is a good enough test under amended 28 also.
No, Lord,
One could have
yes,
a possible view. Over here, as you're aware,
yes,
the first part, even though they go on, it should have been much clearer. The first part, clause 50, is confined to a certain situation, meaning money due upon measurement for actual work done.
lordship, please.
And for that, no interest would be payable. It does not cover any extraordinary situation.
Right.
But the sweeping words,
Yes.
or in any other respect whatsoever,
Yes.
in the second scenario, which is
Lordship, please.
51,
Yes.
is the real bar.
Yes.
Now, Harishchandra said it must be read in the light of what precedes it.
Correct.
Which is not really ejusdem generis, which is different.
Right.
In the light of what precedes government security, and therefore,
Right.
despite Jayaprakash paying lip service to Harishchandra, has actually decided it contrary to Harishchandra after noticing Harishchandra. Therefore, Jayaprakash is binding on us, irrespective of
No, my lord.
Harishchandra would have.
I would respectfully submit, not the reason, the basis of, the basis of distinguishing Harish Chandra or not following Harish Chandra is that it was distinguished in Saeed Ahmed and saying Saeed Ahmed holds the field. But Saeed Ahmed drew the vital distinction in the language of that clause there and the clause in the Harish Chandra. It was not as if Harish Chandra, Saeed Ahmed said that the clause in Harish Chandra was wrongly construed or that even without those words the bar was complete. That was not Saeed Ahmed's ratio. So my respectful submission is, my lord, that, no doubt your lordships are absolutely right that this is unclear. This doesn't, my lord, but it doesn't equally help my learned friend either. The point of the matter is that the only clause...
It helps a learned friend only to the extent that 55 has not been taken into account. If there was a discussion
Yes.
on these lines, erroneous discussion, by referring to 55 and then relying on Harishchandra, this, that or the other, to arrive at a conclusion that no interest was still payable, fine. In 34, 37, we wouldn't have touched it. But there is no reference. It does not take into account
Yeah.
amended section 28. It does not take into account a relevant provision of the contract.
No, I'm not. I'm on the other aspect. I'm on the aspect that my learned friend says they did not take in. First and foremost, my lord, again, I'll have to check about 55 business. But before that, the point my learned friend is canvassing for your lordship's kind consideration is that there is a bar. Now, your lordships are construing the clause. The question of 55 and all that would have arisen, my lord, in a different context, given the fact that the work, my lord, which was delayed was whether or not, my lord, I gave notice and so on and so forth or not. But on the question of interest, my learned friend's case is that this clause, as my lord, is a complete bar to grant of interest. Now, whether the tribunal has considered or not, my submission is that is not a bar at all. Whether the tribunal considers is irrelevant. If, of course, your lordships are to hold that this is a bar, then, my lord, the tribunal is not considered and I am out. But the question is, my lord, whether the construction of the clause can be so placed, because, my lord, as I said, they didn't argue it, so tribunal did not deal with it. Since your lordships are now, my lord, embarking on this inquiry, whether or not, my lord, this constitutes a complete bar is something only your lordships can decide now.
Because both Syed Ahmed endorses Harish Chandra and so does Jayaprakash over here.
Yes.
It endorses Harish Chandra.
Yes. And that is the only clause by itself which is pari materia with mine. There is no other case. Neither Ambika, nor Reliance Cellulose, nor Jayaprakash, none of those cases is exactly the same except Harish Chandra. That is why I respectfully submit, my lord, that it is only Harish Chandra's case and your lordships, my lord, given that their tribunal has granted this, unless it, my lord, your lordship finds something perverse in that, your lordships do not consider
that we don't find anything perverse.
Yeah. So that's my respectful submission as far as this is concerned, that my lord, give the construction of the clause, my lord, does not bar. And that's why, my lord, your lordships are entitled, my lord, the tribunal, my lord, when it's granted the interest, it did nothing wrong. There was no bar which was applicable at all. That's, my lord, my respectful submission as far as the interest is concerned. Now, my lord, I'll move on the other three aspects, my lord, which your lordships had said.
Which are the others?
Which are not explosives and the others.
Reasons.
Yes.
There is a very limited thing that the contentions raised by them.
Yes.
Only two, not three.
Yes.
Explosives and cement.
Yes.
Cement and steel.
Lordship, please.
That the contentions raised were not dealt with.
Yes.
And in any event, adequate reasons were not given.
Yes. Now, my lord, as far as, my lord, the explosives are concerned, now, my lord, first and foremost, when they say that I raised a contention that I had provided the explosives commensurate with the progress of the work, there was underutilization of there must be some document to prove it. It is not enough for my learned friend's client to say that this was a contention raised and was not dealt with. Because the tribunal, what it has done is, my lord, because it was a large contract, it looked at the overall, my lord, the contract and how it was performed. And it looked at the circumstance where, my lord, the hindrance register, for example, which, my lord, the tribunal is referred to, shows a number of places, which is jointly signed by both parties, no explosives, no explosives, no explosives, no explosives. There is no record that they have contrary produced to say that, my lord, as far as they are concerned, that they did provide it. So now the question is, my lord, though the tribunal does not, my lord, expressly say that because you have not provided any document, but there is this other document, that's why I'm going by this particular document. The fact of the matter is that the only documents on record show that there was a delay in supply of explosives. And may I, my lord, just place that hindrance register for your lordship's kind consideration, jointly signed by the parties, which was placed before the tribunal. Because, Lord, the way this is...
we will not look into evidence.
That's what the point is. So, my lord, the tribunal has, based on, my lord, whatever it found, it said, yes, there was a delay in supply of explosives.
Tribunal's award or finding has to be justified by the tribunal's words. Let's come to that.
Yes. So, my lord, may I place that? Your lordship, just come back to the award in a minute. Would your lordships not be so kind as to have page 95. Now, would your lordships just have the third bullet point at page 96? The tribunal finds that the respondent itself did not have the license issued by the controller of explosives for permanent explosive magazine till 2010-2002, that is for a period of more than 1 year from the start of the contract work, and as such had to supply from a portable magazine and arrange from PWD of Mizoram. This aspect was not contemplated or provided for in the terms of the contract. Now, my lord, two things I want to, my lord, emphasize here for your lordship's consideration. What is the net effect of what my learned friend's argument is essentially this. I was supposed to, as in NIPCO was supposed to provide us roads. NIPCO was supposed to provide us materials, which include cement, steel, explosives, so on and so forth. They had to provide us drawings. They had to provide us designs which were, my lord, not faulty. And because of the fact, and they could actually get away by not providing any of this because they have a prohibitory clause. This is in net effect of what they're arguing before your lordships, that in no circumstances am I liable to pay a rupee to you. I may not give you the roads, I will not supply the material, I will not give you the cement, but now you cannot claim anything. It doesn't matter if your man machinery and manpower is idle. That cannot be. Now, in this particular case, they did not have the license. Now, in the contract, they don't reveal that they don't have a license. They say we will supply you the explosives, but they don't have a license for it. They don't tell me. So they know that they are not in a position to supply the explosives. Can they now take refuge in the fact that, my lord, that there is a prohibitory clause which prevents me from, my lord, claiming on account of this? This is quite apart from my overarching argument, my lord, which I had canvassed for your lordship's consideration in the beginning, which was that the principal driver of, my lord, all the delays was the absence of the roads. It had a ripple effect, a cascading effect, as the tribunal has noted, on all the delays. And therefore, my lord, ultimately there is no way to bifurcate and say this particular delay or this particular hindrance, this particular machinery on that account, and so on and so forth. So my respectful submission is the tribunal has taken a holistic view of how the contract has been performed. It cannot be, my lord, divorced and looked at in a blinkered way to say, my lord, that as far as explosives is concerned, this was, my lord, my contention and not dealt with. The tribunal has looked at the hindrance register, which is also mentioned at, my lord, as far as the drawings are concerned, which your lordship will just come back to page 95 for a minute, and it says that it has looked at the hindrance register. This is, of course, in the non-issue of construction drawings. See, kindly have the last bullet point just above C. The AT notes that the respondent has denied the delay in construction drawings and finalizing tunnel alignment submissions, but the AT cannot ignore the documentary evidence of jointly maintained hindrance register as submitted by the claimant. So they have not based it on whatever material was placed before them. So my respectful submission is not on the explosives. The fact that my learned friend says that they were not considered is not accurate, and as your lordships have noted, these are not men of the law, they are engineers. So they know that if the license is not there, there is no way that they will be able to provide the explosives, and the hindrance register shows that they did not provide the explosives. That is, in my respectful submission, sufficient dealing with the argument that was canvassed, and not in 37, which is a rarefied jurisdiction, if I may say so with respect. I would respectfully submit, that your lordships would consider not interfering in the award on that count. Then, I move on the question of, and that's why the tribunal says this is not in contemplation of the parties at all, that you would not have the license, and behind my back you would, and still insist that I should proceed without claiming any compensation. Now, I come to the question of
interest.
Grateful. Just to, on 55, my learned friend is just taken out. The point was taken and we had put them to notice.
Very good. The point is not taken, but I just wanted to.
Yes. Grateful, deeply. Okay, sorry. May it please your lordships.
Now, this immense difficulty comes now. You've not relied on Jayaprakash for the law that it enunciates, but because the clause is in paramateria. Jayaprakash notices Harish Chandra, which is a completely different view. Harish Chandra results in Syed Ahmed, which says Harish Chandra is right, but for this latitude over here. Yours is completely in parameter with Harish Chandra and the second clause in Jayaprakash. And both the Jayaprakashes say that they look at it in conjunction and not independently. If the Jayaprakashes said Harish Chandra is bad, and actually the clause means this, but Harish Chandra is acknowledged to be correct in Jayaprakash, and that's why they rely on both, and that's why there is no sequitur to the argument which is made at paragraph 8. The argument is noticed, but there is no sequitur to such argument.
May I point out the sequitur? Just see paragraph 22. Would your Lordship have paragraph 22, Manoj,
Yes.
of Jayaprakash? Yes. Insofar as the argument based on the principle of adjustum generis is concerned, the division bench has rightly held that this is not applicable in the present case. We find it is rightly so held. Adjustum generis is the rule of construction. The High Court has negated this argument in the following manner. The rule adjustum generis guides us that when two or more words or phrases which are susceptible of analogous meaning are coupled together a nocitur a soci, they are to be understood to mean in their cognate sense and take color from each other, but only if there is a distinct genus or category. Where this is lacking, that is, unless there is a category, the rule cannot apply. As rightly held, the rule adjustum generis would be applied only if there is a distinct genus or category, which is lacking in the instant case. This rule is applicable when particular words pertaining to a clause, category or genus are followed by general words. In such a situation, the general words are construed as limiting to things of the same kind as those specified. In that sense, the rule reflects an attempt to reconcile incompatibility between the specific and general words in view of the other rules of interpretation, that all words in a statute are given effect, if possible, that a statute is to be construed as a whole, and no words in a statute are presumed to be superfluous. The words to be construed here, and the distinction and the fulcrum.
22
Yes.
does not refer specifically to 51.
Yes.
22 deals with, previously they've said that they are going on a conjoint reading of 50 and 51.
Yes.
And 22 proceeds on the basis of 50 and 51 altogether, not only on 51. Number one. Number two, come to paragraph 21.
I'm obliged.
It is also pertinent to note that the judgment in Syed Ahmed distinguishing the restrictive wording in Harish Chandra has been consistently followed in a number of cases. In this scenario, when you find that Harish Chandra, which is of vintage of 40 Act, is distinguished Syed Ahmed, coupled with the fact that the ratio has been consistently followed, there is no reason to deviate. So it says, it does not say that Harish Chandra is bad. All that it says is Harish Chandra has been distinguished, because distinguish and overrule are different things. Distinguished because the ratio will not apply because of some distinguishing feature. In Syed Ahmed, those three rights, all which may become due, is found to be a distinguishing feature which warranted a different interpretation to be given to an otherwise similarly worded provision. And Syed Ahmed stands on that. This follows Syed Ahmed without disturbing Harish Chandra. So therefore, Harishchandra remains binding. And finally, when you come to 22, if you read it on a whole, you can't read it piecemeal, the prohibition is only by reason of a conjoint reading of 50 and 51 and not of 51 alone.
My respectful submission is that the essential question of agestum generis arises in the question of the phrase used in 51. That is, or in any other respect whatsoever. So the fulcrum of the two alternative arguments are A. One is
you elevate the judgment
yes
to a level that the judgment itself does not.
No, judgment read as a whole, in my respectful submission, would, my lords, lead to the construction that I am suggesting for your lordship's acceptance. If I may just make that good.
It is not on a standalone 51.
No, both.
For first.
No, for the purpose, the argument.
Personally, Mr. Abadi, I don't think Harishchandra is a proper construction.
Lordships.
Personally, I don't think it's a proper construction. However, it's binding.
Well,
and several other Supreme Court judgments have referred to Harishchandra and have not doubted its correctness and have proceeded on the basis of distinguishing it only.
Well, may I answer that? So far as the reference to clause 50 is concerned and 51, it is only referred to for the purposes of saying that the latter expression in 51, that is, in any respect whatsoever, should be read agestum generis either with 50 or the earlier part with 51. That's how the submission on agestum generis comes. Harishchandra, as your lordships rightly pointed out, perhaps takes the view that the two are not disjunctive. In any respect whatsoever, has to be read as agestum generis with the class, category or genus formed by 50 and 51.
No. Harishchandra dealt with a single clause.
Lordship, please. No, it's a different.
Did not have
it's a complete. It's a different clause. I'm saying the reasoning in Jayaprakash and the argument which was raised in Jayaprakash is that 50, the content of 50 and the earlier part of 51 has to be read agestum generis with any other respect
or
whatsoever.
In any other respect whatsoever.
Therefore, my lords, the submission in paragraph 22 is that a correct interpretation of those clauses would mean that the expression in any respect whatsoever.
What you're saying is,
yes,
you are asking us to interpret paragraph 22 to suggest that Harishchandra is wrong when paragraph 21 expressly says Harishchandra is right.
Well, I would answer that in this way. But paragraph 22, my lords, also has to be interpreted meaningfully, as having interpreted two identically worded clauses, as which occur, my lords, in my case. Now, I can understand, and that is what your lordship repeatedly pointed out, that clause 55, which has been specifically pleaded, was dealt with by the arbitrators in some manner, and, my lords, on an interpretation,
the second line, that's second line.
Yes. So, firstly, my lords.
First of all, that would come provided there is a bar.
Yes.
If this is a bar,
yes,
this is not taken into account, it goes. But if this is not a bar, so even if it had been taken into account, it wouldn't have been a bar.
Yes. Just see para 8, my lords.
8 has no sequitur.
No, just see the submission. Just see the submission.
Yes.
In 8. Because it's a judgment, my lords, has to be read as a whole.
Yes.
If your lordship sees paragraph.
Submission.
Paragraph 8, my lords. And it's on 51 alone. The submission is based on 51.
8 is only on 51.
Yes, my lords. Kindly see paragraph 8, my lords.
Yes.
If your lordship would be pleased to read it along with me. Dilating on the first submission, an attempt of counsel was to show that the clauses in the contract in question, when interpreted correctly, would clearly bring about these clauses did not prohibit the arbitrators from granting interest. The learned counsel emphasized the word or any other respect whatsoever occurring in clauses 51 of the GCC and argued that these are to be read adjustum generis and should take their color from the earlier part of the clause. He submitted that when these words are read in the aforesaid manner, it is only those cases where some amount or balance is lying with the respondent because of any dispute, difference, or misunderstanding between the parties, etc., interest is not payable. Such a situation would not arise in those cases where claim is raised on other counts and awarded by the arbitrator. He also submitted that clause 51 in the contract in the instant case was similar to clause 1.9 of the contract in Harishchandra, and the court interpreted the said clause to mean that the arbitrator was not precluded from awarding interest. In this view, his alternate submission was that two similar or almost identical clauses are interpreted in a different manner in Harishchandra and Jayaprakash Associates case, and therefore a conflict arises which needs to be resolved. And this conflict is what is resolved by their lordships in paragraph 22.
No.
But yes.
The reason for Jayaprakash is that there is only one genus, which is monies or balances. We had a second genus because the clause is not in pari materia. The orange portion is...
But my learned friend had a point. You make it. If your lordship permits. Make it.
If your lordship sees, there's also a distinguishing feature in clause 55 as compared with Jayaprakash. And that may be relevant because there are various categories specified in 55, whereas there is only one category in 1.9, which is Jayaprakash. Would your lordship see page 67 of Harishchandra, my lord? The clause is set out. No claim for interest or damages will be entertained by the government with respect to any money or balances which may be lying with the government owing to any dispute or differences or misunderstanding between the engineer in charge in making periodical and final payments. One category, and then, my lord, in any other respect whatsoever. Now, if your lordship would have Appendix C side by side, and I'll explain to your lordship why there is more than one category here. No claim for interest or damages will be entertained by the corporation with respect to any money or balances which may be lying with the corporation owing to any dispute, difference, or misunderstanding between the engineer in charge on one hand and the contractor on the other. This is, till here we are on the same ground, my lord. Or with respect to any delay in the part of the engineer in charge making periodical or final payment, or in any other respect whatsoever. So, unlike this clause where there are multiple categories, just as in 50 and indeed 51 in Jayaprakash, there are multiple categories. Harishchandra dealt with a single category and any other respect whatsoever. So its ratio makes sense because there is a single category of payments with that. In all the other cases, whether one clauses or two clauses, including our own, my lord, there are multiple heads or categories of payments specified in a single clause within any other respect whatsoever. And that's a crucial point of distinction, my lord. I'm extremely sorry.
Why not? If you come to 55,
please, my lord.
If you come to 55, that or cannot be a disjunctive or. That or is continuing in the same sense. With respect to any money or balance, not that or. That or is, part of that description. which may be lying with the corporation, then the reason for it is owing to any dispute, difference or misunderstanding between the engineer in one charge on one hand and the contractor on the other, or with respect to any delay on the part of the engineer in charge. So both are reasons attributable to the engineer. So it's only one category, not two different categories. This all which you read, or with respect to any delay on the part of the engineer, is the same, and therefore the next or must also be read as delay on the part of the engineer on any other count whatsoever.
My lord, with respect, that may not be the case because the portion on dispute and difference is with respect to money or balance. So it cannot necessarily be with respect to delay. If
go slow, with respect to any money or balance, which may be lying with the corporation,
please,
owing to any dispute or difference, misunderstanding between contractor one and the engineer and contractor.
So with respect, there cannot be any delay in respect of a money or balance. So I would read this clause as, from the beginning, my lord, no claim for interest or damages will be entertained by the corporation. Then we go to what I, in my respectful submission, say is a disjunctive or interest or damages with respect to any delay on the part of the engineer in charge in making periodical or final payments. Because the prefix to the first category is money or balance which may be lying in the corporation. And that money or balance, it doesn't make sense to read that with delay in payments. And with
don't follow what you're saying.
One of the first part of first category relates to money or balance which may be lying with the corporation.
Money or balance which may be, so what happens? There is a dispute between the engineer and the contractor. As a result, the engineer does not clear certain payment to be made to the contractor. So the money which is lying or balance which is lying, it should have really gone to the contractor, but is lying with the corporation because of dispute between the contractor and the engineer has not cleared it for payment.
Your lordship is absolutely right, and that is a debt which has crystallized, but because of any dispute, it's not being paid. Delay is a separate issue.
Now then see, or with respect to any delay on the part of the engineer.
Please, my lord. Usually any
so there's a dispute and there's a delay because lack of consideration, or in any other respect whatsoever, would still get governed by the, you see this one, no claim will be entertained with respect to any monies or balances,
please,
which may be lying with the government, owing to any dispute, difference or misunderstanding between the engineer in charge in making periodic or final payments, or in any respect whatsoever. So he says that the or in any respect whatsoever will be governing owing to this or owing to any other reason attributable to the engineer in charge. This also means the same thing.
May I make one attempt, my lord?
Yes. Not only one attempt, collect your thoughts, come back after lunch, both of you, please. Because if this turns on this, this turns on this. We are not shy on that. But try and collect yourself and
please
make us understand, both of you.
Lordship, please. Annexed unit.
Don't touch on this. Read exactly like this.
Your Lordships will resume at 2 o'clock?
2 o'clock.
Lordship.
Little bit won't fall.
Let me carry this. What is the main?